Dear students, welcome to week 13, module 3 relating to the monitoring bodies under the Inter-American Regional System. In the last module, we saw the Organization of American States, principal organs under the Organization of American States, and the main human rights instruments which have been evolved, particularly the American Charter and also the American Convention and the further human rights instruments. In this module, we take up the monitoring bodies. Basically, there are two of them. One is Inter-American Commission on Human Rights, and then second, there is an Inter-American Court of Human Rights. These are the two main monitoring bodies. And first, let us take up the Inter-American Commission on Human Rights. Over the years, it has evolved into a unique institution, and its role as an organ promoting the observance of human rights across OAS members was recognized, and its status has been enhanced to that of a principal organ of the OAS Charter itself, and it has a dual role. Initially, it started as a charter based body in the sense that in all member states which have signed the OAS Charter are supposed to adhere to the human rights commitments mentioned in the American Declaration on the Rights of Man. Later, the American Convention on Human Rights was adopted, and then this American Commission, which started as a charter based body, also became a treaty based body. So, for those countries which have signed the American Convention on Human Rights, the American Commission also has a monitoring role. It monitors the implementation of the human rights commitments by member states. Now, let us look at the mandate of the Inter-American Commission on Human Rights. In fact, it was created in the year 1959 by the Organization of American States, and as I said, its mandate includes fulfillment of the commitment by member state both under the American Declaration as well as the American Convention of Human Rights. In fact, there are 7 members who are elected by the General Assembly of the Organization of American States for a period of 4 years, and in fact, these members serve in their individual capacity, and they form the Inter-American Commission, and they make recommendations to states on the adoption of comprehensive measures, and they also prepare studies and also bring out reports on human rights matters from time to time about the conditions in member states. In fact, under the Inter-American Commission, a number of reports have been submitted on issues like rights of indigenous peoples, terrorism, human rights defenders, violence against women, and other such issues. In addition to these roles, the Inter-American Commission can also conduct on-site visits to member countries and bring out mini country reports or country reports. Of course, if you look at the American Convention, there is no explicit reference to the country report, but as a part of the mandate, the Commission undertakes these visits and also publishes reports and to its parent body, and also tries to further the observance of human rights. The Commission can also ask states to inform it as to the measures taken. The Commission can also entertain complaints or petitions from individuals, groups of individuals, non-governmental organizations about the violations of the rights which are contained in the American Declaration as well as the American Convention. Now, these petitions, like in other international procedures, one is expected to exhaust the domestic remedies before approaching the Inter-American Commission. But if you look at the Article 46 of the American Convention, there is a provision to do away with the requirement of exhausting domestic remedies in cases where the domestic remedy is taking unduly long period of time, in cases where the domestic remedy is ineffective and so pursuing it will be of no consequence. In such cases, one can directly approach the Inter-American Commission, and these complaints are examined from the standpoint of admissibility in the first instance, and those cases which are admissible, an attempt is made by the Inter-American Commission to secure a friendly settlement among the parties involved. In case the friendly settlement is not reached, in case the efforts to find a friendly settlement fail, then the case can be taken to the Inter-American Court of Law either by the state concerned or by the Inter-American Commission. So, this is how the a case typically ends up with the Inter-American Court of Human Rights. And in addition to these functions, the Commission can also request for a issue of an advisory opinion by the Inter-American Court of Human Rights on any issue or any right which is mentioned in the statutes, particularly whenever there is a lack of clarity on the interpretation. The Inter-American Commission can seek the issue of an advisory opinion, and the Commission can also has a responsibility to monitor the human rights conditions in member states, undertake on-site visits, and also bring out special reports or carry out research and issue publications. This in a sum is the role and functions of the Inter-American Commission on Human Rights. Now let us look at in greater detail the role of the Inter-American Court of Human Rights. The Inter-American Court of Human Rights was created in 1969. It is a supreme judicial organ established under the American Convention of Human Rights. It enjoys both contentious jurisdiction as well as advisory jurisdiction. As far as individual complaints are concerned, only states, that is 35 member states or Inter-American Commission can take a matter to the Inter-American Court, but individual has no standing before the Inter-American Court. The court comprises of 7 judges who are elected for a period of 6 years by the General Assembly of the Organization of American States, and they serve in their individual capacity. And the court is based in San Jose, Costa Rica, and it mandate is to interpret the and apply the provisions of the American Convention on Human Rights. And in case after following the due process, if the court were to file a violation of American Convention, it can recommend the award of a fair compensation. It can recommend that the right that has been violated be remedied. And in fact, I will give you a few examples. There is this landmark case of Velasquez Rodriguez versus Honduras. In fact, this judgment by the Inter-American Court of Human Rights created a lot of further action in other regional systems and as well as the international system. Here, a person disappeared on account of the actions of the let us say state agents who were in a not in their official dress, and later on a complaint was made to the police and law enforcement machinery, and so and there were eyewitnesses who saw the Velasquez being picked up from by, and there were also eyewitnesses about him having been seen in a public facility, detention facility. Now, at the end of the this case, the court held that the state had a responsibility to investigate diligently any such complaint which comes before the law enforcement machinery, and also prosecute those who are responsible. And to that extent, it did not buy the argument that it was the handiwork of some private individuals, and it held the state liable, and it found a violation of the American Convention. And this landmark case has led to further work among the other jurisdictions, and it also inspired many other cases, and it has given a big fillip to the issue of disappearances and formulation of further legal standards. Now, let us come to the one more case of Barrios Altos. In this case, Peruvian army were trying to help a death squad, and in an anti-terrorist operation they fired upon a group of civilians, killing 15 of them and seriously injuring 4 of them. And thereafter there was an amnesty law that was passed in Peru, and as a result of which army personnel, police personnel and civilians who were responsible for human rights violations in the period 1980 to 1995 were given amnesty. And so this left a serious gap with those victims and their kin of who were killed or injured in the mass firing, and they took this matter to the Inter-American Commission and thereafter the Inter-American Court, and here the Inter-American Court found a serious violation of the American Convention, and also asked the government to memorialize, acknowledge the wrong that has been done, and also ask for appropriate action. This in a way captures the work of the Inter-American Commission or Inter-American Court of Human Rights. Generally, the decisions of the court are expected to be binding, and it is the final. There is no further appeal on the judgments, and all states are expected to take action based on the decisions. But there is no enforcement mechanism to enforce the judgments. Unlike in the European system, you have a committee of ministers where there is a committee of foreign ministers who supervise or who enforce the judgments of the European Court of Human Rights. Here, the Inter-American Court submits an annual report to the General Assembly of the Organization of American States, mentioning cases where which there is a lack of compliance by states, if any, and along with serious recommendations. And so this in short is the two monitoring bodies which are available in the Inter-American system, namely the Inter-American Commission on Human Rights and the Inter-American Court of Human Rights. Both have done remarkably well over the years and have evolved wealth of jurisprudence. Of course, there exists serious challenges in the Americas, including drug trafficking, crime, human rights violations, and many other serious challenges. And of course, their effectiveness needs to be further improved in the times to come.